Okay, good afternoon. My name is Julia Coakley, Head of Operations, and on behalf of the MGAA, I'd like to welcome you to our webinar this afternoon, which is being delivered by ICSR. Before I introduce our presenter, may I ask that during the webinar you ensure your camera and microphone is off. If you'd like to ask a question, please use the chat button at the bottom of your screen, which will be answered at the end of this presentation during the Q&A session. If we run out of time and don't have an opportunity to put your question to our speaker, this will be responded to post-event. This presentation is accredited for CPD points if relevant to your ongoing professional development. The video will be available on our website and our MGAA YouTube channel, and I would ask you please to complete the SurveyMonkey feedback survey in order for us to be able to put on the best quality events for our membership. If I could just ask again if microphones could be switched off, please. So today's webinar, What Has Changed in the Regulatory Environment in Recent Years for MGAs, is brought to you by ICSR, and I'd like to introduce Kenneth Underhill, Director. Kenneth founded ICSR in 2017 and has over 25 years in the London insurance market of experience. He is the former General Counsel for Chubb European Group, then ACE, and has held posts as Director of multiple insurance companies operating in over 30 countries with a turnover in the range of $5+ billion. Kenneth has been responsible for legal, compliance and corporate governance across EMEA region and has overseen large teams. Kenneth was also a founding partner of the commercial and regulatory team at Reynolds Porter Chamberlain. So Kenneth, if I might hand over to you.
Thank you very much for that introduction. Right, we've got quite a lot to get through today, but what we're going to do is we're going to start with two questions, which may or may not feed into what we talk about later in the presentation. But if we could just get up now for everybody, the first of the questions. We're going to give you about 30 seconds to answer these. If you could use your voting buttons now, that would be very helpful. You can't see what I can see, but it's very interesting. It's moving all over the place.
So we've got quite the fight between governance and Brexit authorisation, Kenneth, at the moment, and team response.
Yeah,
has taken the lead marginally.
Okay, let's give it 10 more seconds, shall we? All right, let's close that out and put the results up, please. So there you go. It looks like governance has been the most issue that people have been dealing with in recent times, which is quite extraordinary given what happened last year with COVID and the Brexit as well. So interesting. Wasn't the one I was expecting, that's for sure. So let's move on to the next, if we could. Let's take that out. Now I have to do that on my, sorry, I have to do that on my slides. Right, now we're going to move to the next question. We have another question. Sorry, this is taking a bit of time.
Okay, so our next question is, what regulatory matter has caused the biggest debate within your business in the last 12 months? So at the moment, it looks like Brexit, perhaps unsurprisingly now, actually Brexit is steaming ahead. COVID-19, again, probably expected, but Brexit is absolutely the one, it seems, that many organisations are truly debating about, with quite a significant lead over other topics that you've suggested there, Kenneth. So if we want to give it just or two.
Yeah, give it a couple more seconds. I don't have it on my screen for some reason. Hopefully when you change it to share, I'll get it back.
Okay. All right, so just a moment more, if anyone wants to submit a response, what regulatory matter has caused the biggest debate within your business in the last 12 months? So I'm going to close the polling now. And Kenneth, can you see the results?
I have the results. Yeah, there's some link issue when polls are up for me to change pages. Brexit, most debate. That's interesting. So governance is the thing that most people have dealt with, but Brexit is the thing that has caused the most debate. And then COVID-19 is at the end. All right, interesting. And then the other ones are roughly all the same. Op-res is quiet. Now, I think op-res is quiet because it only applies in the broking and MGA sector to firms which are enhanced firms. So if you're an SMCR enhanced firm, op-res is definitely in your world. If you're not, then it's not going to apply. And nobody has had a debate about culture. Not a single person. Well, maybe it hasn't been the biggest debate, but that's quite interesting. Okay, so could we, if we can move on now, because we are going to lose time if we don't. Now I have a problem again with moving to the next page. I'm sorry about this. This happens every time we do a poll, and we don't actually know why. Right, okay, so what we're going to do today, previously what we've done is we've looked at the current plan and then the next year's plan and done a bit of a comparison. I actually want to go back a bit further because I think there's a journey we need to go on now to understand where we are and where we're headed. And so we're going to start at 2016, which is roughly about the depth of the recesses of my memory. I'm not sure I can go back much further than that these days. And this is what I'm looking at. I'm looking at sort of FCA directives. This doesn't include handbook updates or quarterly consultations or consultations about fees or anything like that. This is just the major consultations that were taking place in the FCA in 2016. And what we see here is sort of the 40 plus consultation papers that were issued by the FCA. Only 3 of them were specific and relevant for insurance. Of the 25 policy statements, there was only 1 major policy statement for insurers, and of the 10 plus finalised guidance, there's 1. So that means consultation papers, insurance represents 7.5% of consultation papers, policy statements 4%, and finalised guidance 10%. Context. It's 8 years since the global financial crisis. At this point, you sort of feel that insurance is still following in the shadow of banking and other financial services markets. But what I think is that we're going to see that that is no longer the case. So let's have a look. Let's have a look at what was happening pre-2020, 2018. So we've got themes and priorities, 216, 217, 218, financial crime, wholesale markets, advice, innovation and technology, culture and government, treatment of existing customers. Now, it won't surprise you, you see some of those are still there, and we will look at those later on. And the high-level principles that appear most are these. PRIN 3, 4, 6, 7, 9, and 10, but significantly, almost all regulatory action that resulted in a decision prior to 2018 is based on PRIN 3 or PRIN 6, and more PRIN 6 than PRIN 3, but often PRIN 3 may be included with PRIN 6. And what that sort of means is that what's behind that, I think would be a better way of looking at it, is that while the rules, the detailed rules may be used in the analytics phases of regulatory action, say a 166 or a market study, when it actually comes time to take action against a firm, the FCA will rely on the high-level principles. And there are a couple of reasons for that. The first one is causation. It's very difficult to get a good fine where they have to rely on a specific rule, because it's difficult to prove that a breach of that specific rule has led to customer detriment. Whereas if you say that there has been a breach of Principle 6, it's much easier to get, not a conviction, but a result. It's also less easy for a firm to argue against a principle than it is against a specific rule. And that, of course, means that it is harder to appeal a finding on a principle than on a specific rule. So what do we see after that? Well, if we move forward, I'm going to start again. We've still got 2017 here. These are the FCA plans. These are the cross-sectoral pieces. So these are the issues that are covered by the FCA 217 to 221 for all financial services sector. Okay, and you know, in 217 and 218, we have Andrew Bailey, who is the CEO of the FCA. In 219, for a while, we have an interim CEO, Mr. Woolard is there. And then what we find is in 219 to 20 year, that's actually 220 plan, into 221, it's Nick Rathi, the current CEO. And if we look at some of these things, all of these should feel familiar to you. All right, you'll have seen all of these in one way or another. Future of regulation has sort of disappeared off the map. Climate change has popped up. Interestingly, in 2019-20, you'll see wholesale markets has dropped off of the cross sector, and you'll see that existing customer issues has dropped off the cross sector. And of course, Brexit has turned up. If we move, however, to the insurance, specific insurance issues, what we see is that wholesale markets hasn't dropped off. It's not showing in 2021 plan because by then it has been rolled up into the value and governance in distribution, but wholesale broking is still an issue. What we also see is that vulnerability and access has remained a key issue in the insurance sector. So there are some things here which are very specific to the insurance sector. And 218 is what I call the full house, okay? And I call it the full house because not only have we got the IDD implementation, which brings in the product governance rules and the best interest rules, we also have the super complaint that comes in and which ultimately leads to a much heavier look at pricing practices. And so for me, this is the real year, and it's part of the reason that I chose this as the main piece, or the main, I guess, the core of where I start from looking at what's happened. And the interesting thing that we see, if we look at some of these subjects, so there's a movement here towards a level of detail that we haven't seen. Before this period, there had been very few market studies. There had been a market study, there wasn't a market study ongoing at the time, we'll come to that later, but there had been a market study in mobile phones and a couple of other bits and pieces, but there hadn't been too many. We also hadn't seen, you know, a lot of detail in consultation papers and policy statements unless they related to EU requirements such as the IDD. So, for example, in 2019, we have the GI distribution final guidance. It's 21 pages long. Then by 2021, what we're getting is, for example, fair treatment of vulnerable customers. That is a finalized guidance to 2021. That's 55 pages. And then we can look at policy statements, 2021, the general insurance pricing practices policy statement, 88 pages. So we're seeing here a greater level of focus on the insurance sector. We're seeing here a lot more detail in what the FCA is looking at. And what I want to move to now is just to look at some of the tools used and the timelines, because this is quite interesting as well. What we've now got, if we look at culture, for example, these timelines, by the way, these are extracts from our website. So if you want to see the full timelines, then please do go to our website. You will find a lot more detail. There are direct links to all of the discussion papers or consultation papers, etc. So it's available in more detail. But let's start by looking at the tools used in culture. So culture didn't require, the focus on culture by the FCA hasn't required a new set of rules. They can rely on PRIN 3 and PRIN 6 pretty easily for these. So the approach they've taken is discussion papers, and they've done those initially by themselves and then ultimately with the PRA and the Bank of England. And a discussion paper isn't something that, you know, sets out a detailed level of rules, but what it does do is it gives you a sort of guidance on where they are and what their expectations are. And that's quite important, because what's interesting, and we will see later, is that there are, until this stage, no, there's, other than the odd Dear CEO letter here or there hasn't been any issuance from the FCA which just says this is what we expect. Okay, you get the odd Dear CEO letter or you get a discussion paper. So if we look at distribution, the tools that are now being used are consultations. And there's a reason for that. The distribution, IDD, was coming in 2018. That was an EU requirement, so the FCA had to actually bring rules into place. And the interesting thing about this is that they actually used 3 consultation papers, resulting in 3 separate policy statements. So if you remember 2016, there were only 3 consultations in that entire year, but just for distribution alone, we now have 3 consultations, 3 policy statements, different topics. One's on product governance, another one is on best interest rules, and then there's one on IPIDs and etc. But so we're seeing an increase in the level of detail being provided by the FCA. We're seeing an increase at this stage in focus on insurance as well. And right at the end, after all of the policy statements are issued, we even get a final guidance after a consultation. So we're seeing a lot of interest in distribution and a lot of different tools being used by the FCA right up to 2019 to 20. All right, if we look at a couple of others, pricing issue. What we've got here is we had a market study. Of course, this is where the super complaint kicked in. We had a market study. We had an interim report, then we had a final report. There was sort of a bit of consultation and discussion around the original report. And then we go straight into consultation and we end up with the policy statement, which is 88 pages long. So here, what the FCA is saying is, well, we're going to look at this. There's a degree to which they needed to be seen to be doing something. So a market study was probably the best place to start. There was a real reaction to the super complaint. So they needed to go in and do a market study just to make sure that they understood what the concerns and issues were. And again, market study through to consultation, through to policy statements. Then we look at vulnerable customers. Again, this is a topic that they're able to rely on current rules. TCF PRIN 6 is sufficient for them. The guidance under TCF is available. All they therefore needed to do here was to use a guidance consultation or 2, followed by a finalised guidance. And again, guidance may only be issued as guidance, but you would be foolish if you didn't follow their recommendations and their guidance. We then move on. OpRes has been going on since 2017 at a high level, then it moves into discussion paper, it moves into consultation paper, and ultimately policy statement. Now the interesting thing about this is that it's quite high level. So unlike the detail that you get in the pricing approach, unlike the detail in vulnerable customers, here you've got quite a high level policy statement. And the reason for that is it's cross-sectoral. And I'm not sure that the use of language there works perfectly for insurance, but it's there. it's high level. What it does require is a significant amount of work for those that have to comply with it. So again, a different approach. We've seen that in some cases they start with a market study which ends up with a report and consultation. In this case, a discussion paper ended up with a report, a consultation and a policy statement. In some ways it depends on who's driving this. And then SMCR. So SMCR came out of the global financial crisis, and it started with a consultation paper. It had then a policy statement, was followed up with a guidance consultation, followed up with a guidance, followed up with some statements on expectations. So again, a different route. And what we're seeing here is that throughout, the FCA is using different tools. Most of them, I haven't gone into the detail on the SMCR piece, but the guidance for firms on SMCR is probably longer than the policy statement. And that, came out later on as well. All right. So let's have a look now. We get to 2020, and we are absolutely in Nikhil Rathi's first full year as the CEO. Mr. Woolard has moved aside. Nikhil Rathi has stepped up, and like many, he's been hit with the impact of COVID-19. And what we're now seeing is a completely different approach. It's rapid, it's providing clarity, and it's very, very direct. So there are guidances used. There's quite a few finalized guidances after very short consultations. Some of those consultations were a week, some were 2 weeks, but they were very short. And we're seeing Dear CEO letters being used all over the place. We're receiving information from the FCA, which is not guidance, but should also be considered similar to guidance. And we've got statements of expectation. So the FCA and the PRA have used this, and it's never been used in any detail or in any quantity previously. And I suspect the reason is that if they had to issue guidance, then they would have to consult. So they've simply issued a document called their expectations. If they went into guidance, it would have to be official and it would require a consultation. So if you look at this, quite a number of these are simply FCA expectations. And as we know, there was another first here that they issued civil proceedings against multiple defendants. They have issued civil proceedings before. They use civil proceedings to enforce their requirements. This is the first time that they have actually decided to take steps to protect consumers and policyholders by issuing civil proceedings in their interests. So this is March. This just shows the amount of activity that's going on. All of this is insurance specific. And in the insurance sector, what we have here is 11 topics are covered. Not all in these boxes, but the topics included business interruption claims, how to deal with complaints, which staff are or should be considered key workers for the purposes of going into the office, how to treat vulnerable customers, and that is not just vulnerable through illness, infirmity, age, whatever the case may be, but also financially vulnerable. There were also they also covered op-res. They then, I think the first time ever, they covered financial resilience. And financial resilience was not just about customers, therefore vulnerable customers, it was also about insurance firms. So there were quite a few MGAs, quite a few brokers who were monoline to some extent. And their products were in real jeopardy you know, travel insurance, for example. If no one's traveling, no one's buying, and there is no money to pay staff and others. But there are also other topics which were which were covered. Also included delays to reporting requirements in conjunction with the FRC, Financial Reporting Council. There were delays to filing documents at Companies House. And of course, there were delays to FCA consultations, which were underway. The point about this is that the FCA was getting right into detail here. They were being very clear about what their expectations were and their requirements were. And they were being very direct to firms. Some of those Dear CEO letters, I think I'm not sure that I've read language in them that are in previous years. So let's go and have a look at where we are. Now, I know 2020 is an unusual year. Everybody knows that. But I have a feeling that what happened during COVID-19 and what's happened in the insurance sector with the lack of positive response to claims is going to have the sort of impact on the insurance sector that the global financial crisis had on the banking sector. I think we have probably done ourselves a disservice as a market through this, and I think that what we are going to see is a greater focus on us. And one of the easy ways to show that is through the numbers. So these directives, again, it doesn't include the handbook guidance, the quarterly the quarterly consultations. These numbers are purely insurance related key policy statements, consultation papers, and finalised guidance. So it also doesn't include the real significant increase in the use of Dear CEO letters or the use of these expectation statements. And if I can take you back, 2016, 3 consultation papers out of 40, that's 7.5%. Now, we've got 4 consultations out of, I think it's 21, almost 25%. So that is an uptick of a multiple of 3. If you look at policy statements in the insurance sector, we've gone from 4%, 1 in 25, to 6 out of 15 or so, which is almost 40%. And in terms of finalised guidance, we are now 100% of the finalised guidance that was issued by the FCA, which are key significant finalised guidance. So there is this shift in focus on our industry, and I think that we are going to see more of that. So you all were hoping to hear about this year's plan. Let's talk about it. There's Nicole Rathie, the CEO, and I think before I actually talk about the key areas, the background to this. He's taken over, and then we've had COVID-19. So everything that's happened during COVID-19 has told him that the insurance sector needs to lift its game a bit. But additionally, he's used tools that have not historically been used before. Expectation statements, a lot more Dear CEO letters. So they have been used before, but nowhere near the level of significance that they were during COVID-19. And while all of that was happening, there's been an independent inquiry underway in relation to something called London and Capital Finance, LCF. I'm sure that many of you have heard of LCF. It related to the sale of unregulated bonds by a regulated entity, but the actual activities relating to the bonds was unregulated. And that report, that inquiry, has been highly, highly critical of the FCA. And the reason it's been highly critical is because the FCA didn't test its perimeter boundaries. And so, needless to say, one of the things that Mr. Rathie has said that they are going to do is be more proactive at the perimeter boundaries. So they're going to be looking much more closely at what firms do and whether it's regulated or unregulated, and what the impact of that may be. But no surprise, his statement is that they are going to be more innovative. They're going to be more assertive, and they're going to be more adaptive. Well, I sort of feel that we already know that they're more assertive. I think that we have seen that, and I think that that is going to continue while Mr. Rathie is in charge. And they're going to use data and other tools to identify potential harm more efficiently and effectively. And this actually, I mean, if you think back to the issues and topics, we saw that when Andrew Bailey was in charge of the FCA. He started to look at what big data could do for the FCA and how they could collect information. And I think a really good example of that is the paper that's come out on general insurance pricing practices. There's quite a significant section there on reporting to the FCA on pricing issues. And I think that that's something that they're getting to grips with, is there are better ways, there are more detailed ways in which they can collect data from firms about their activities and about what they do than they have in the past. So we're going to, I think, see in the longer term a lot more reporting on issues in a way that can be cut and stacked by the FCA and used as an analytical tool going forward. So the key areas won't surprise anybody. Almost every one of these, in fact, every one of these except appointed representatives, has been on the list for the last few years. They don't often change their list, as we have seen. Most of the topics have been there. Financial crime, climate change is new, but they are looking very closely at that. Needless to say, one of the things that they have looked at is climate change reporting. So that goes back to that use of data and tools piece. Brexit, they've got 2,500 firms in the TPR, of which 99% are expected, well, it may not be 99%, but I'm assuming that about 99% of those firms are going to be expected to make an application for authorisation. So their authorisations team has a great deal of work. And it's going to be even more because Mr. Rathie has decided that he needs to raise the bar higher for firms to become authorised. So right at the time that they have the highest ever level of potential new entrants as authorised firms, they've decided that they're going to raise the bar higher. Yes, okay. So fair value, we know that the policy statement is out. There's going to be implementation. I wouldn't be surprised if there was a review of where firms have got to with fair value to make sure that they are implementing it. Certainly quite a few of our clients have done so or are significantly down the path of doing so. Financial resilience, that is now about firms themselves. Again, going back and looking at the financial security of the firms in the market. You'll recall on one of my very early slides that I mentioned the minimum standards that are required. Let me just quickly go through that. The threshold conditions are on slide 7. The FCA is going to do some work to check that people are meeting those requirements. It's not something that they have historically done, but I think that they feel that now is the time is right because of the impact of the number of firms which have been which are monoline and have been impacted by COVID-19. And appointed representatives, I think this is another need to to look at the correct question of perimeter boundaries. Appointed representatives are something that initially came out of the IMD and then were contained within the IDD. The UK took it a little further than the EU, than many EU regulators did. But it does mean that there are quite a lot of firms out there who don't have a great deal of oversight. And there are firms who are principals to those appointed representatives who probably don't have in place the level of oversight that they should have. So we can expect quite a lot of focus and work on that over the next year or two or three, because as we have seen from the earlier slides, none of these issues, once they're on the list of things, or not, most of these issues, I should say, which are on the list, are there for a number of years while the FCA and all the PRA in some cases work their way through them. All right, so that's the plan for this year. Very little new, but what I feel, or I hope you are now feeling, is that the approach to this market is changing. When Mr. Rathie says that he is going to be more assertive, I think that we can assume that a degree of that is going to be pointed towards our market. Right, so what do we see? I sort of summarised this as I've gone. First thing is not everything which is cross-sector eventually becomes a focus in the insurance sector, but often it does. And when it does, in some cases, the approach is not that easily translatable. And that, I guess, is a specific statement on my view of operational resilience, but it has applied elsewhere as well. When the FCA does focus on the insurance sector, it will now be going into several layers of detail. I mean, if you look back at the approach to the mobile phone market, for example, the market study followed by guidance, it wasn't detailed, it wasn't in any great depth. You know, the guidances leading up to 2019, 21 pages here, 25 pages there, and now we're seeing a real significant increase. And we are importantly seeing a significant increase in the number of detailed rules which the FCA can use, and I think will apply. But they have so many different tools. They're now doing supervisory meetings for many firms, which they hadn't done previously. They're doing group supervisory meetings. There's the Dear CEO letters. We've already seen that there's been a significant increase in those. Market studies, I think we'll see more of them. Section 166s, so market studies often lead to either a Section 166 or, for some firms, straight into regulatory action. 166s are often used as a tool to see what a firm is doing. Both market studies and Section 166s often lead to a consultation and feedback statements, and they themselves can lead to either finalised guidance or policy statements. And for the firms that haven't met the standards that the FCA expects, you get regulatory proceedings. And I think we can also expect in future more civil proceedings. Generally, they have been used more in the investment market, where you have people trading offshore and undertaking regulated activities here. I think we will see that they will be used more in the insurance market. What I also feel is that the most powerful rules remain the high-level principles, but I think product governance is going to be an area that the FCA will use. It's a detailed set of rules, and I just have this feeling that they are going to provide them with a lot of ammunition, if you want to call it that, or a lot of opportunity. And the consumer duty, the best interest rule. So in the financial services sector, it's consumer duty. Under the IDD, under the IDD rules that were brought in the UK in 2018. It's called the best interest rule. And that basically, I mean, it's a really interesting concept, but it brings to anybody who distributes insurance products, insurers and brokers and MGAs, a rule that treats them almost like they were an agent of the insured. And it has a friction point when you're dealing with claims. Is payment of a claim under a policy appropriate? What does the wording say? Is it covered? Is it not covered? What do you do where there is a real question over whether it is covered or not? Do you have to apply the best interest rule or not? One for the lawyers more often than not. And of course, SMCR. Now, I'm going to refer to, I'm sure most of you have heard of the Lloyds Bank decision recently, where they agreed a fine of over 900 million for activities in selling insurance products to customers. Now, the interesting thing about that particular fine was that it related to the information that they were providing to their customers. And it related to the detail of the products that were being sold. And yet, because those activities were pre-2018, there is no mention of product governance rules. There's no mention of SMCR, and there is no application of the best interests rule. And that's how the regulations work. You can only be fined for the applicable regulations at the time of the activities which are being complained about. And the issue for the FCA at this point in time, and the issue for the market, is that you can't get a feel or a guidance for what will happen going forward from that case. But what we do know is that COVID-19 happened after 2018. And what we do know is that the product governance rules were in place during COVID-19, and the best interest rule was in place during 2020, and SMCR was in place during 2020. So the FCA hasn't taken action against individuals yet under SMCR. It's yet to utilise the best interest rule. The reason? At the moment, it's taking 2 or 3 years for proceedings to come through. So some of those things are happening. And I think that one of the things that people are going to need to recognise, certainly I think out of COVID-19, we are going to find out how the FCA is going to apply the product governance requirements. How is it going to use those to take action against firms? And it's almost, you know, firms that came out during COVID-19 and said, hang on, but this cover, it wasn't designed to cover a pandemic. Well, that's almost an admission of a failure of the product governance requirements that they had in place. And I think what we will learn certainly in the next few years is just how important the FCA considers product governance, how important it considers the best interest rules and SMCR and how it will apply them. And I have a feeling that we're going to see firms that, you know, have not done well during COVID-19. We're going to see them appearing on final decision notices from the FCA. So where do I think we're going? I think we're going to see, as I've said, a lot more detail in the rules that apply to the insurance industry. I think we're going to see a lot more focus from the FCA on our industry. And I'm now ready to take any questions about any of those issues.
Thank you, Kenneth. Very interesting, as always.
Yes.
A lot of ground covered there, but all clearly very relevant to our membership, and a great attendance. I do have a question regarding one of your slides. I think it's slide 7. And the question is, what does raising the bar for authorised firms mean? Is this in relation to all firms, i.e. ASIPs, financial firms, etc., or does it have specific insurance context, i.e. more capital requirement for brokers, MGAs?
Okay, so I think that's actually about Nico Rafi's statement. So that is slide 14. But I have taken you back to the threshold conditions. So the threshold conditions are here on 7, capable of being supervised, appropriate resources, financial and non-financial. Now, threshold conditions are the thing that a firm must meet before they are authorised, and they must always, after they are authorised, meet those conditions. If they fail to, then the FCA will withdraw their permissions. And the key one there is appropriate resources. Financial resources have to be appropriate to the business model of the firm. So if the firm is turning over 50 million, then there will be a level of financial resource expected. If it's turning over 500 million, there will be a level of financial resources expected. That is capital. But it also applies for non-financial. So, you know, if you're an MGA and you have multiple lines of products that you are selling, say you're selling professional indemnity and offshore energy with a specialization in wind farms or something like that. If you have PI underwriters, but you have no offshore energy underwriters, then the FCA would probably consider that you didn't have the right non-financial resources. So that's not just about the level of resource, it's about the quality and experience of those resources. And these rules, there are no numbers, okay? There is a minimum capital requirement you have to have if you're a small firm, and that increases. So there's a 5% or a 2.5%, but at a certain stage, it goes beyond that. And, you know, those are the minimums. So I think that we will see the FCA starting to look, because it will be tied into that question of financial resilience. So I think upping the bar, I think we will see the FCA looking closely at firms' financial resources. But I also think that we're going to see them looking at the non-financial resources and other threshold conditions. So, yeah, I hope that answers the question.
Thanks, Kenneth. If the person that submitted that question, if you didn't cover it or there was any further additional comment you wanted to make, please drop it in the chat. We don't have any further questions at the moment, but should there be any questions that come in kind of last minute, hopefully you'll be happy to answer them post-event, Kenneth, if, as I say.
I'm very happy to. Maybe it's because I looked at bigger picture rather than the specific topics, but I'm happy to answer specific topic questions as well if somebody has a question about D&I or fair value or something.
Okay, thank you. Okay, well, there are no further questions. I don't have any to put to you, Kenneth, so I think it just leaves me to say thank you, as always, for your time. As I said before, the content of your presentations are always very, very valuable to our membership and cover plenty of topics and certainly food for thought. And appreciate if there are any questions, if you're happy to answer them post-event. Again, we'll be grateful for you doing that. So thank you for your time.
All right. Well, thank you everybody for joining us.
Thank you. And to all of the delegates, if you would please be kind enough to complete the Survey Monkey survey. I do reiterate this to all our webinars, but it really is important that we hear your views on our webinars. So if you could take, it's really no more than 3 minutes just to complete that survey to let us know what you think, give us some feedback. And in particular, if there are any topics that you would like the MGAA to cover for you, we will get the appropriate subject matter experts in to deliver those presentations to you. So thank you again for your time. Have a great afternoon. Thank you.